Okay.
All right, members, we're open formally now to the public. Okay, so having declared the meeting open to the public, could I just do the usual routine advice about members using their electronic devices and so on, the switch phones and so on off, please. And could I just ask members who are using any reference any pages or so on, could I just refer to the page number at the top of the page? Thank you. Okay. And could I invite any members to declare any interest relevant to today's meeting? None being declared, then we move on to apologies. We have no apologies recorded yet, so any apologies to record? None that I'm aware. Okay, just to move into matters arising. Just to note that today's the first in a series of Tuesday meetings running up to Christmas recess, specifically to deal with the consideration of the pensions bill. The department will brief the committee today, and it's also available to return on the 2nd and the 9th of December for additional briefings depending on the progress made today. We have been liaising with stakeholders to expedite oral evidence sessions starting next Tuesday, and so far only NIPSA, as I understand, has confirmed it will give evidence to the committee on the 2nd of December. Obviously then, I suppose we anticipate that the committee will take a second briefing from the departmental officials on the 9th of December to address issues raised by the stakeholders and oral evidence. But again, this will depend on the level of engagement that we do get. And could I just then ask the officials and give them the go ahead to schedule any briefings and so on relevant to this session? I agree with that, thank you. The call for evidence was issued to stakeholders on Friday past, and the notice for the public consultation will be published in today's papers. The deadline for submissions is the 16th of December, so depending on the number of responses, meetings and stakeholders may be scheduled in January. We'll see how we get on with that. The motion to extend consideration stage of the bill was led in the Business Office following your decision last Thursday at the committee meeting. And as was noted last week, the committee will endeavour, of course, to complete consideration stage within 30 days, but this extra time will allow for any delays that the committee might actually face. Moving on then to the main item of the agenda, it's the Pensions Bill Committee stage, the departmental briefing. We already had an introductory briefing on this bill a while ago, and at that briefing the bill was described as a mixed bag. The committee will have an opportunity now today to tease out the positive and negative implications of the bill and establish what opportunity, if any, exists to effect any change. Gary McCann and Seamus Cassidy are here this morning to lead the briefing, and Noel McCleary has had to attend another meeting, but will join Gary and Seamus in due course, and other officials may of course join as required. Obviously now members will have an opportunity to put questions to the department on each clause, and if any questions occur to members following the briefing, committee staff will be very happy to follow up in writing. So, members, the officials are here this morning, hopefully to get through as much of the bill as possible. We can only book the room until 12:30, so we won't be able to go beyond that. And the department officials, of course, will be able to return at the subsequent Tuesday meetings to cover the remaining parts, if necessary, of the bill. Okay, so could I then just formally then welcome Jerry and Seamus this morning, and Libby. Okay, Libby, thank you as well.
Hello everybody.
Just the main members in next NIPSA will be here next week to provide their briefing. Okay, so Jerry, over to yourself, Seamus.
Okay, so good morning everybody. And so what we aim to do is to actually start off at the start of the bill, and we will just work our way through. And so Seamus should be taking the first part of the bill, and he will be giving you a very brief answer outline of what is in each of the various clauses. And so if at the end of each clause you have any issues which you wish to raise or be asked us about, we will be all very happy to turn on. So.
Good morning, Mr. Chairman.
Members are aware that the Pensions Bill proposes changes to the state pension, private pension provision and bereavement benefits. Part 1 of the bill deals with the state pension. In Clause 1, state pension creates a new benefit called the state pension for people who reach state pension age from 6th of April 2016. A person attaining pensionable age before the 6th of April 2016 will not be entitled to the new pension, but may be entitled to benefits under the existing rules. Clause 2, entitlement to the state pension at a full or reduced rate. This clause sets out the basic entitlement conditions under the new scheme. To be entitled to a state pension at the full rate, a person must have reached pensionable age and to have 35 or more qualifying years. State pension entitlement will be paid on a pro rata basis where a person has qualifying years between the minimum and maximum levels. The minimum number of qualifying years will be set by regulations, but will not be more than 10 years. This clause also defines qualifying year as a tax year during which a person's working life where the person's earnings factor were equal to or greater than the qualifying earnings factor for that year. For a qualifying year, a person would need to have paid, been credited with contributions or earnings equal to 52 times the lower earnings level in that given year. Qualifying earnings factor in 2014-2015 was about £5,772. In order for that year to count state pension purposes, Clause 3 deals with full and reduced rates of state pension. Clause 3 provides that the full rate of state pension will be specified in regulations, which will be subject to the confirmatory procedure and require Assembly approval. Once set, the rate cannot be reduced. The clause sets out that the reduced rate of the state pension is 1/35 of the full rate multiplied by the number of qualifying years for which an individual has accumulated. That, of course, is subject to the minimum qualifying rule of 10 years. Clause 4, entitlement to a state pension at transitional rate. This clause provides for a transitional rate of new state pension and sets out the conditions that a person must satisfy to be entitled to it. The person must have reached state pension age, have more than the minimum number of qualifying years, and have at least one pre-commencement qualifying year, i.e. a year post 6th of April 1978 and before 6th of April 2016.
Can I, Seamus, sorry, I don't want to interrupt your flow there, but just in terms of, and this is for myself, my own information, see as we're going through this, I mean, you're straight into the clauses. I wonder, is there a possibility of just getting like a kind of brief synopsis of really what this is about? I know you, Gary, you just did that, but it was very quickly.
Yeah, well,
I wonder, could we just get a wee sense? You know, where we're
well,
actually
as stated at the outset, you know, the bill, as you said yourself, it's a mixed bag. There are changes to the state pension, private pension provision and bereavement benefits. Right, specifically, the bill will introduce a new state pension, and there's a number of consequential matters attached to that. There will be an option for people to boost their state pension onto the existing rules. That'll be people who don't qualify for the higher new state pension. The bill will also deal with accelerating the increase in state pension age to 67. The committee has previously dealt with the increase to 66, so this is a further step in that direction. It will also phase out the assessed income period for state pension credit, and will introduce the new bereavement support payment to replace current existing bereavement benefits, and there are a number of changes to the private pension provision. Is that sufficient, Mr. Chairman?
in terms of what are described as the negative and the positive implications, could you maybe just give us a wee bit of a flavour of that?
The positive aspects of the new state pension, of course, will be the fact that it will be set at a level that's higher than the current means-tested benefits. There are some negatives in that the number of qualifying years will increase from 30 to 35, and there will be a minimum of 10 years. for a person to qualify for any state pension whatsoever under the rules.
Okay, thank you. Thank you.
The option to boost the additional state pension is
Seamus, could I just ask, if it be set higher than the
pension credit level.
Yeah.
Yeah.
So does that mean, because obviously with pension credit or fringe benefits, now, does that mean that if you are slightly above the pension credit level that would have existed, that you won't get, there'll be no fringe benefits accruing to your state pension?
But what it'll mean in most cases is that people will have to apply for things like housing benefits, etc. There'll be no automatic passport through to it.
But presumably with pension credit, which is to supplement the low income, because really you're talking about it being slightly higher than the existing benefit, which is subsistence level. So it'll be slightly higher than subsistence level, but you may then lose fringe benefits which accrue at the moment to pension credit. So there's
No, well, we don't expect anybody to be losing any of those fringe benefits, just as Seamus says, as opposed to you know, actually moving straight on to those. It's just that you would have to put in your application form for the likes
So
of
the,
HB, for example.
the obligation will be on the claimant.
Well, again, I actually want you to claim your various benefits, but you're also told, you know there are, that you can also get other benefits, and if you wish to claim, this is how that you.
No,
can
I'm
do
just
it.
thinking in terms of the issue around when somebody used to be in benefit, they would automatically be entitled to rate rebate. That would all be done automatically. When it was introduced that the person had to apply, loads of people were losing out simply because they assumed because they were in benefit, they automatically got it. So there need to be some sort of campaign, if you like, done to ensure that people
Well,
are aware that they have
actually,
to
just
do it.
on that general issue, our colleagues inside of the SSA, they should be doing a very extensive, as it were, communications campaign. And in fact, I'm sure that they would be happy to come. It's in front of the committee to advise as to how this would be done.
Because
If
it
you
is,
find
it's
that
a
helpful.
big issue for people.
But I do know that there is to be a very, I think it's a long and also it's a very staged campaign. Which
Because even today, I've been dealing with people who assumed they were getting rate rebate, then they get a bill out.
Yeah.
You can't understand because
Yeah.
they're in income support.
It's just, but under this new scheme, our aim is that everybody will be on, it's £148.40, just using that as an example figure, which is just, it's above, into the pension credit level. So therefore, but we couldn't just move absolutely all those people straight on to housing benefit because
fine.
most wouldn't be entitled to it.
Thanks.
Okay. But if you want us to arrange for somebody to brief the committee
Yeah,
about the
I think it
communication strategy, we'd be very happy to do so.
But the other side of the coin is that since there's a large number of people who currently probably could be claiming pension credit and aren't claiming pension credit by taking the basic pension up above the pension credit level, there's no need then for people to apply for pension credit.
Yes, that's very true, and I do know this from my own mother that I couldn't get her to claim state pension credit. She just wouldn't do it, and so why would I have to get my bank book in?
But there's almost £2 million a week, because by 1.9 million unclaimed in pension credit weekly. Which goes back to the Treasury, it doesn't go back in.
Yes, which and so the benefit of some of these changes anyway is that people will automatically be put on to a level which they would have been put on to had they applied for pension
Yes,
credit, so there's no need for that.
And since
It's an optimistic use of the word benefit.
And again, prior to our colleagues inside the SSA have been doing quite a bit of work to try to help people to claim, state pension credit.
Yeah.
There's a lot of work going on there as well.
Yeah, they've been operating the uptake programme since about 2005, and they estimate that to date they've spent about an additional 50 million on about 15,000 older people, and
What's that figure again?
about 50 million pounds additional since 2005, benefiting about 15,500 people. And again, the programme's already running for this year, and they expect to target about 25,000 older people in this year.
Okay, so thanks for that. Back over clauses.
Let me just start where finished.
Yeah, please, Seamus, yeah.
Clause 3, it's full and reduced rates of state pension. Clause 3 provides for the full rate of state pension to be specified in regulations, and once the rate is set, it cannot be reduced. This clause sets out that the reduced rate of state pension is 1/35th of the full rate multiplied by the number of qualifying years which an individual has accumulated, and again that's subject to the minimum qualifying rate of 10 years. Clause 4, entitlement to state pension at transitional rates. This clause provides for a traditional rate of the new state pension and sets out the conditions that the person must satisfy to be entitled to it. The person must have reached state pension age, have the minimum number of qualifying years, and have at least one pre-commencement qualifying year, i.e. post the 6th of April 1978 and before the 6th of April 2016. If a person is entitled to state pension at a transitional rate, they will not be entitled to a new state pension under Clause 2. The clause provides that the minimum number of qualifying years will be set by regulations but will not be more than 10 years. Pre-78 reckonable years will count towards meeting the minimum qualifying period and the pre-commencement qualifying year requirement. Traditional rate calculations will be set out in Schedule 1 in detail. Ensure that nobody will get a state pension lower than the value of their national insurance record in the existing scheme, subject to meeting the qualifying period requirement. Clause 5, transitional rate of state pension. Clause 5 complements Clause 4 and sets out the basic calculation of the transitional rate of state pension and cross-refers to other provisions in the bill with which it interacts. Where the foundation amount is more than the full new state pension amount, the excess is paid as an additional component to the transitional rate, and this is known as the protected payment. Where the foundation amount is less than the full new state pension amount, post-commencement qualifying years count towards the transitional rate up to the full new state pension amount. The transitional rate is to be operated under the applicable paragraph of Schedule 2, and the amount corresponding to the full rate of the new state pension will be operated in line with earnings. Any excess will be operated in line with prices. Clause 6 deals with the recalculation and backdating of transitional rate in special cases. This is a technical provision which enables the transitional rate of state pension to be adjusted after the person reaches state pension age, and this reflects backdated changes made to the person's national insurance record. It applies where a person's employer has paid the state pension at premium to reinstate a person's additional pension in lieu of private pension benefits, and they were contracted out for a short period. To ensure that the valuation is correct, Clause 6 enables the transitional rate of the new state pension to be recalculated and backdated. Where a premium has been paid, without this clause, the transitional rate of the new state pension may be undervalued as amounts are deducted to reflect periods of contracting out. Clause 7, survivor's pension based on inheritance of additional old state pension. This clause makes transitional arrangements for the inheritance of a deceased spouse's or civil partner's current scheme additional pension. A person is entitled to a survivor's pension based on inheritance of an additional old state scheme if they have reached state pension age, their spouse or civil partner died while they were still married or in a civil partnership, and they are entitled to an inherited amount under Schedule 3 based on the deceased spouse's or civil partner's additional pension entitlement. The state pension under this clause is payable equal to the inherited amount and is to be operated in accordance with Schedule 4. The clause provides a regulation-making power to set an upper limit to the total amount of a survivor's own state pension plus their inherited state pension. Clause 8, choice of lump sum or survivor's pension under Section 9. This clause sets out the qualifying conditions for the clause to inherit either a lump sum or a survivor's pension from a late spouse or civil partner where the deceased had deferred their old scheme state pension, and it provides for the calculation of the lump sum.
Seamus, could I just ask you there, in terms of the lump sum, would that be a situation with a person that could have a lump sum or a pension?
And the deferral.
You'd have to have some calculation how long you're going to
Yeah,
live to benefit, where you benefit more from the lump sum or the...
it is for people who, under the old scheme, have not taken their pension. At the moment, you can opt either to take a lump sum payment or instead to be paid an extra piece of pension every week. And so all this is doing is just carrying that forward.
Yeah, but it's the
so
same-
that
it's the
choice
same
doesn't exist.
principle. You'd have
Yeah,
to
it
say
is the
the-
same principle.
the same-
And for some people, they will want the lump sum. For other people, actually for tax
Yeah.
purposes, for example, but they might want a lump sum paid all to them inside 1 year. So they would opt for an extra pension.
Thank you.
Clause 9, this deals with the survivor's pension based on inheritance of a deferred old state pension. Clause 9, it follows on from Clause 8 and replicates the existing legislation by setting out the qualifying conditions for inheritance of a survivor's pension from late spouse or civil partner where the deceased had deferred their old scheme pension. The state pension under this clause is payable at a rate equal to the inherited amount and will be uprated in line with prices as now. The clause provides for that a person may be entitled to inherit more than one pension under these provisions. It also sets out that there are other provisions that may affect entitlement to an inherited increment, for example, under Clause 19, where prisoners are concerned. Clause 10, inheritance of graduated retirement benefit. This clause provides a regulation-making power which will set out the circumstances in which a new state pension recipient may inherit entitlement to a graduated retirement benefit, including a deferral sum, and their late spouse or civil partner from their late spouse or civil partner who had accrued entitlement under the old scheme. This replicates existing legislation in place for the old state scheme, in particular the power to amend this clause by regulations. Regulations may provide for the surviving spouse or civil partner to exercise a choice of inherited payment where the deceased had built up entitlement to a lump sum payment or an increment under the old scheme. In the current system, regulations provide for a person to inherit half their late spouse's or civil partner's graduated retirement benefit. The intention is to use the regulation-making power to replicate the effect of the transitional arrangements for mainstream inheritance, as provided for under Clause 7 and Schedule 3. In other words, where the spouse is in the current system and the survivor will still be able to inherit half their graduated retirement benefit, provided, as with the main transitional arrangements, the marriage predated 2016. Where the spouse is also in the new state pension system, their graduated retirement benefit will form part of their current system evaluation and will be subsumed in their new state pension. The survivor will inherit half of any protected payment. Clause 11, reduced rate elections, effect on Section 4 pensions. This clause provides transitional arrangements to address the impact of abolishing deferred entitlement to a basic state pension on women who opted to pay the married woman's stamp. That's the reduced rate national insurance contributions. The provision is made for women with reduced rate election current at 35 years before pensionable age, but subsequently had qualifying years before A-Day, and therefore has some entitlement under Clause 4. A minimum qualifying period doesn't apply, and basically a woman who qualifies will get at least additional pension plus Category BL if married, or Category A.
What's that mean?
That's it means that they will be able to get what they would have got under the old system, and an amount equal to it. The CAT BL is the rate which is paid to a spouse based on what had been paid by their spouse. It's currently payable at about so £67.60 per week. If the spouse is actually dead, then there is a higher rate payable, and that would be the rate of £113.10. Oh, okay. Yeah.
Clause 12, reduced rate elections, pension for women with no Section 4 pension. This clause provides transitional arrangements for women with a reduced rate election in force within 35 years of reaching pension age, but with no pre-A-Day qualifying years.
I think Mr. Brady.
So you see that reduced rate elections, was that to do with what used to be called the small
Small
stamp?
stamp.
It's before
Which was just for-
1977. It's a woman who was married
Which
or
was the home
whose spouse had
responsibility,
died,
the home
you know,
protection.
she could opt to pay a small stamp.
And is that, you know, because the idea of that was that would go towards pension for women who work, stop their work and have a family.
No,
Right,
well,
that's a different thing, isn't it?
well, actually, again, but it was linked into the idea that at that stage, it's a woman would be able to get a pension based on what had been paid by her spouse.
So the small stamp is actually taken into account.
So the small stamp actually,
that was only really
that
for
meant for
industrial-
her that she didn't earn
Yeah.
any rights to pension at all. And that's why that we are now making special provision for
That
those
changed
women.
in 1973, I think. So
Well, actually, up until 1977, you know, they could opt, and then after 1977, but you know, they actually couldn't. So any woman who is caught in this had to have actually made that option. It's before 1977.
okay, thanks.
In essence, the conditions of a title mimic the current rules. So if a woman is married or a civil partner, her pension is payable at category BL rate. If divorced or widowed before pensionable age, or marriage or civil partnership ends after pensionable age, it's payable at the category A rate, which is the £113.10. The only difference is that the basic amount won't directly depend on the husband's national insurance record. Instead, in the interest of simplicity, it will be standardised at the full rate. Most men will have a full record by 2016 anyway. If a woman has any qualifying years for the period between A-Day, when she reaches state pension age, she will get the higher of the new state pension under Clause 2, or her basic amount under this clause and Schedule 7. Clause 13, shared state pension on divorce. This clause allows sharing of some state pension between divorcing couples by creating a pension credit. It provides for all state pension credit where a person is entitled to a credit because of a shared additional pension. A new state pension credit where a person is entitled to a credit of a shared weekly amount because of a shared excess amount under Section 4. And Schedule 8 sets out the appropriate rate. Schedule 9 provides for uprating. If total state pension, including the credit, is less than or equal to the full rate state pension, it's uprated by earnings, or equal to more than the full state pension credit is uprated by prices. If the pension is less than the full rate but greater than the pension credit added, it's uprated by earnings up to the full rate and then by prices. Clause 14, pension sharing, reduction in the sharer's Section 4 pension. Clause 14 creates a pension debit that allows a person's pension to be reduced to comply with state scheme pension debit. i.e., this is to allow the pension to be shared for the state pension credit. Pension sharing credits and debits only apply to the protected payment in the new state pension scheme and additional pension in the existing scheme. Clause 15, pension sharing amendments. This clause introduces Schedule 11, which amends the relevant legislation to reflect the introduction of the new state pension scheme and to give effect to pension sharing under the new scheme in transitional rate cases. The effect of the amendment is to retain the existing arrangements for pension sharing orders made prior to the 6th of April 2016 and to enable the protected payment to be shared in pension sharing orders made on or after the 6th of April 2014. In particular, entitlement to a shared additional pension that's under the current scheme will be confined to people reaching state pension age before A Day. It does not affect the validity of pension sharing orders issued before A Day. Clause 16, pensioners' option to suspend state pension. This clause permits a pensioner in the new scheme to qualify for an increment by suspending their entitlement to a new state pension for a period of time. It replicates existing arrangement for old scheme pensioners. Increments earned will be operated by prices, and that is the case at present. As with the current state pension deferral scheme, they can only do this once. There is no time limit on how long a person may defer, and people may be able to change their mind and backdate decisions for up to 12 months and get arrears. Clause 17, effect of pensioner postponing or suspending state pension. This clause provides for what happens as a result of a person choosing not to claim their new state pension, known as postponing, or choosing to give up their new state pension for a period after it has been awarded, that's suspending, and stipulates the criteria to be satisfied in order for a new state pension to be deferred. The person who defers will be entitled to increments, and they'll be subject to a de minimis rule of 1%. The percentage rate will be set in regulations. Such a person will be entitled to have one increment for each whole week in the period during which that person's entitlement to a state pension was deferred. The person is not entitled.
Sorry, just on the postponing or suspending, at the moment, under the old scheme, somebody could defer until I think 70. If a man became 65, he didn't have to. So there's no end period in this. So could you say if somebody was working in their 70s, could they defer their pension, or is there a time and they have to?
No, they are now free to leave it for as long as
So they can leave it as
wish.
long as they want?
It's the same also too with the private pension as well, because sometimes people hit that age and they didn't want to take it for various other reasons. So this, no, they should be able to carry on.
There's no
there's no
end
end.
as such. That's okay.
And is there any reason why they can only then take it as an increase in their pension rather than an increase in pension or a lump sum?
Well, this is just part of the new scheme that the lump sum, at the moment, actually the lump sum is actually all very generous. People in it actually get back everything which they've got, and they also get interest paid at about 2% above the actual rate of Bank of England. So all that had been said at a time when actually interest rates were very much higher, and we were actually living in a very different world.
Just saying, you can almost use that as a form of savings, in a sense. Well, I mean, not.
Well, indeed, actually, and so that is true for this, but it's also true for other forms of pensions.
Yeah.
People do use them as a savings vehicle. I suppose more so for the private, because actually with it, but there are extra breaks for tax purposes.
But it increases the longer you defer
Yes,
it.
you will carry on earning more and more. Yes, you will. You will.
Okay, thank you.
You're taking a gamble and living longer, aren't you?
A person will not be entitled to any state pension for the period they have deferred it. They have to defer all their state pension entitlement and not just part of it. Pension is deferred if it is suspended under Section 17 or not claimed. Section 18. Section 17, supplementary calculating. This clause contains a power to modify the calculation of the increment due when a person has received another Social Security benefit, or there has been a change of circumstances during the period of deferral. In particular, it provides for calculating weeks, etc. For example, Clause 18 stipulates that regulations may provide circumstances in which a part week is to be treated as a whole week. A day does not count in determining a whole week. It also allows Section 17(4) to be modified where a person has been an overseas resident, e.g. where the person has lived in a frozen rate country and the rate is calculated from what would have been payable if that country was not operated. Clause 19, prisoners. This clause provides that where a person is imprisoned in lawful custody or unlawfully at large, pension is not payable. Regulations may prescribe that this applies only if a sentence or a specified description is imposed. i.e. that's suspended if on remand and then repaid if appropriate. It maintains the current position, which has been in place for over 100 years. If a conviction is quashed, considered on a clause-by-clause case basis, taking account of any other compensation. This clause is not removing entitlement, but removing the payability of the pension whilst the person is imprisoned, detained in legal custody, or unlawfully at large.
Sorry, can I just ask, obviously there's been a lot of prisoners over the years, and they will not have their contributions credited for the period that they're in prison, presumably. So to qualify for the 35 years, they're going to have difficulty when they reach pensionable age, presumably, because their record's going to be short.
Well, again, I suppose as we length the amount of time as the person had spent in prison and then as to what they have done afterwards.
But even if somebody's done 20 years, say, and they then go to work, they'll have a number of contributions, but for that period when they're in prison, they won't.
Yeah.
So they're not going to qualify. I mean, it's going to apply to a fair number of people here in the north who have spent time in prison, who are approaching pension every day.
But just as we move forward, which is what we're talking about for this new scheme, for example, assuming that you left school at age 16 and state pension age, you should be 66 now, inside a couple of years, then that still gives you, the number of years inside your working life then is actually 50 years. So even if a person has been in jail periods of time, there still would be other years to allow them to make
Yeah,
up.
but I'm just thinking of people who spent for quite a number of years.
No, it's in terms of what we're saying here and for prisoners, but this has been around for about 100 years, this rule, ever since the very first Pensions Act.
But I think it will become more relevant for more people.
Yeah.
Time goes on.
But I say, with this rule, it's just what is there at the moment, and we aren't
just
changing
a
any of the current rules.
And there are existing provisions that credit people where convictions have been overturned or quashed. Those they're already.
That's fine, thank you.
And does that include where the royal prerogative of mercy has been exercised?
Sorry, I didn't catch
Does
that.
that include where the royal prerogative of mercy has been exercised?
I don't know the answer to that. We would have to check that out. I just don't know the answer. We'll certainly can see if we can find that out for you. Okay, can you know?
Clause 20 deals with overseas residents. This clause provides a regulation making power to provide that overseas residents are not entitled to operating, depending on their country of residence, and this mirrors the current policy. The clause defines an overseas resident for this purpose as someone who is not ordinarily resident in Northern Ireland or any other territory specified in the regulations. People in specified territories will be entitled, e.g. EEA countries, and those countries with whom the UK has reciprocal arrangements. Again, this maintains the current position. Clause 21, the old state pension. This clause defines old state pension as used in Part 1 of the Bill, Category A and Category B retirement pension. Clause 22, general. This clause provides general definitions of terms used in Part 1 of the Bill. It also provides that in the case of a polygamous marriage, the inherited amount is payable only where there is only one surviving spouse. Okay. 23 is amendments. It introduces Schedule 12 and contains amendments relating to the introduction of the new state pension. Clause 24, abolition of contracting out for salary-related schemes. This clause gives effect to Schedule 13, which contains amendments to abolish contracting out for salary-related schemes. Contracting out ends because under the new state pension there will be no state second pension to contract out of. As additional pension will no longer accrue, the option to contract out will no longer be available. Ending of contracting out means that employees and employers will no longer be entitled to the national insurance rebate. They will pay the same national insurance rate as other employees and employers. Private sector employers may amend schemes to take account of their increased liability. Schedule 14 sets out details of how that power may be used. It cannot be used in relation to public service schemes or schemes of a prescribed description. It can only be used to recoup actual costs of increased national insurance contributions, and Schedule 13 removes redundant provisions and protects contracted out rights already accrued. We move on to Part 2, which is the option to boost old retirement pensions. Clause 25.
Can I just take you back,
Yes.
please, to clause 24?
Yes.
And the ability of the employer to amend an occupational scheme because they have to make increased national insurance contributions for this scheme. Does that mean that the cost of the additional employer's contributions can then be passed on to the employee through an amendment or reduction in the occupational scheme? So really, the increase in employers' national insurance contributions may not be an increase in employers' contributions at all, but a penalty on the employee.
Well, effectively, that is the case. The power will exist for only 5 years. And the intention is to try and preserve the salary-related schemes that we have. They've been in decline for a number of years now. And I think many views were expressed that schemes could close if there was no
I think the point about a defined benefit scheme is that the employer does that out, as it were, of his own goodwill. There is nothing in law to say that they have to run the scheme. Yeah, and so this is it's entirely voluntary. Most of the defined benefit schemes are actually, that's what we would class as being very good schemes. And so the last thing we want is to find any schemes are being, as it were, shut down because of what we're doing. And so this is therefore aimed to help the scheme stay open and to keep running. But it's an answer to what you're asking. Yes, the effect could be either that the employee has to pay in more to the scheme, or that he might get out, so slightly less. However, the amount that he pays more for, or the amount he gets less in pension, can only actually be the same as to what is the extra costs for the national insurance contribution. A scheme actually has to actually issue a certificate and to say that that is the case.
But part of these pension reforms have been sold on the basis that the improvements in the pension or the basic pension are as a result of a combination of changes in the retirement age and increases in contributions. But what you're saying by employers, but what you're saying here in this clause here, that where there's a pension scheme or a private pension scheme being run by the employer, that really the costs of the increase in the basic pension can be passed on to the employee.
Well, yes,
the employer decides.
yeah, essentially that is what we're saying. And the reason is that we don't think it would be in anybody's interest for these schemes to close, because most of these schemes are actually very, very good schemes. Therefore, and say that we were to force the private sector employer to pick up this cost and say, he says, well, oh, okay, that's it, but I'm not running this scheme anymore. Oh, okay, that doesn't benefit the member. And in fact, it's probably going to harm him quite significantly. So again, as we said at the start of this bill, the bill is a mixed bag. If you are making changes, but you always have to have some element of it being a trade-off inside it. But I'd say that's why it's just that we are anxious not to end up with schemes closing.
Yeah, but you've said that the actuary would ensure that the person, the employee, wasn't any worse off because the defined pension scheme could not be reduced more than the additional contributions to the employer. But overall, if you look at it, your private pension scheme is protected by you making by some of the additional contributions being passed on to you.
But I think the other point you have to bear in mind from the point of view of the employer is at the end of the day, if there is any gap in the scheme funding, but he has to make that up. And so the employer has actually entered into this contract, which is open-ended nearly, which is why over this past number of years these schemes have been actually shutting down, simply because the costs for the employers are so high. So I say for all this, and there is an element of it being a balancing act.
So if that does happen, are you saying then there is a guarantee? Because could the employer still plead that circumstances have changed by so much that we've got to change the shape of the final pension even after making this kind of an adjustment? Or if he makes this adjustment, does that exclude the employer from pleading that since making that adjustment, since passing on some of my additional contributions onto the employee, things have so changed that I'm going to have to cut back on your private pension scheme? Or once he does that, is that the guarantee given to the employee that he can't offer you your private pension?
For a scheme to be a defined benefit scheme, a contracted out scheme, which is what they've been up to now, they have to meet what's called a test scheme standard, which is really that you look at a scheme which is actually said that this scheme should actually provide X, Y, Z. So, and if your scheme is doing that, well, that meets the test scheme standard, and that is fine. Most schemes will actually pay out more than the test scheme standard. The employer is always free to enter into a negotiation with his members, say that he says, look, I can't afford to carry on paying, and he can enter into a consultation process with his members to change. And sometimes, even if the overall benefit ends up being cut slightly, but it's actually better than the scheme going totally.
So are you saying that in this case, with this clause here, that the employer could say, look, I've got additional national insurance contributions to make, I'm going to amend your scheme to reflect that, and then still at the end of the day say, by the way, I'm going to have to negotiate an even lesser scheme because see, since I've passed those national insurance contributions on to you, or the effect of those on to you, the situation with the returns on the pension scheme have got worse. So therefore, we're going to have to look at a reduction in your final benefit.
Well, I think those are in a way actually two separate issues. One is what we're doing in the bill, which is saying that it is possible for the scheme rules to be altered and to allow these contributions to be recouped. Okay, that is one separate issue. Your second issue then is what could happen at any time for any scheme. If the employer is already meeting everything that he has to under law, and the rates of benefit he's paying are more than he has to pay under law, he is at any time actually free to go to his scheme members and say, look, I can't afford this anymore. Our firm is, that we're not having the best of times. So therefore, what I think we should do, and for the scheme to actually keep on running, is to alter the benefit structure slightly. Now, again, but it's what you have to ask yourself. Well, actually, which is worse? Is it worse for the benefit schemes to be altered slightly, or for the scheme to go totally? Because the employer is free at any time to walk away. Because he's actually doing this, and he is actually bearing all of the risk really for the scheme funding. Yeah, you know, so I don't think it's a case that the employers are actually getting a free ball from this, because the employer is the one who, at the end of the day, has to bear the ultimate risk.
But you could argue the policy intent is to protect the employer rather than the employee, which is hardly surprising from the source that it emanates from.
Well, it's to protect the scheme.
No, I think that the reason is to protect the scheme and to do our best to ensure that these, which are by and large all very good schemes.
Not always that easy to defend the indefensible, but carry on, Jack.
Well,
Well, I mean, I could also
Party should know.
It's
Right, stick to the agenda, folks.
it's estimated that 90% of people reaching state pension age in the first 2 decades under the new scheme would actually get more from the new scheme to offset higher national insurance contributions and reduced occupational pensions. But under this clause, the protection of the scheme is the paramount concern.
Okay. Thank you.
We're moving on to the part 2 now, which is the option to boost old retirement pensions. This clause gives effect to, this is clause 25 now. This clause gives effect to Schedule 15 of the bill, which contains amendments to the Social Security Contributions and Benefits Act. Schedule 15 allows for the payment of extra units of additional state pension to individuals who have made Class 3A voluntary national insurance contributions. Class 3A contributions were introduced by the Pensions Act 2014, which this bill corresponds to. And as national insurance contributions are an accepted matter, the provisions in the 2014 Act extend to Northern Ireland. The purpose of this amendment is to allow people who reached or are due to reach state pension age before the 6th of April 2016 to gain an increase in their additional state pension by paying voluntary national insurance contributions. It will provide groups such as women, the self-employed, low earners and carers who have poor state pension outcomes under existing rules due to low levels of additional state pension entitlement, with the opportunity to reach with the opportunity for those who reach state pension age before 2016, with the opportunity to pay for additional state pension if they wish to do so. The scheme is due to start in October 2015, and therefore the bill must be in place before then. Clause 25 introduces Schedule 15, which makes provision for additional pension to be awarded in respect of Class 3A contribution. The state pension top-up scheme, as it will be known, is due to be available from the 12th of October 2015 to the 1st of April 2007. Any? Okay. Right, part 3 deals with pensionable age. Clause 26 deals with the increase in state pension age. This clause accelerates the increase in pensionable age to 67, and this will be between April 2026 and March 2028, which is actually 8 years earlier than under existing legislation. It amends paragraph 1 of Schedule 2 to the Pensions Northern Ireland Order 1995 and the timetable for moving to a state pension age of 67, which was added by the Pensions Act Northern Ireland 2008. Individuals in each 1 month cohort will reach pensionable age when they reach 66 and a specified number of months. Have you any questions on?
Okay, members will just, if you don't mind, members will kind of indicate as we
Okay, we move on to part 4, state pension credit. State pension credit, phasing out of the assessed income period. This clause amends the State Pension Credit Act Northern Ireland 2002 to provide for the abolition of the assessed income period in pension credit cases from April 2016. The assessed income period removes the requirement for an individual to notify the department of changes to their retirement provision, and that is broadly defined as capital, annuities and retirement pension. They excused this for a defined period for the purposes of assessing their entitlement to pension credit. However, fixing retirement provision for such long periods has led to inaccuracies and benefit awards which have remained in the system for some time, so that provision will actually be removed then. Clause 28, preserving indefinite status of certain existing assessed income periods. This clause clarifies that existing indefinite assessed income periods will remain valid. The assessed income period, the indefinite assessed income period, again was introduced by the Pensions Act Northern Ireland 2008. Part 5, bereavement support payment. Clause 29. This part of the bill contains measures to replace the current bereavement benefits with a new bereavement support payment. Bereavement benefits form an important part of the state safety net. However, the current system is based on a complicated system of payments and contributions to determine eligibility. A single bereavement payment with a simplified contribution condition should reduce the complexity in the system. The new benefit will focus on support on the period immediately after bereavement and will consist of a lump sum with instalments over 12 months. The precise amount will be determined nearer to introduction. However, indicative values are in the region of a lump sum of about £5,000 and a monthly payment of £400 for 12 months for those with dependent children. Those without children will receive a lump sum of about £2,500 and a monthly payment of £150 for 12 months.
Yeah, it was just to clarify, because I'd asked it before about pensioners who have dependent children.
Yes.
Was there overlapping benefits, presumably, bereavement and pension?
Yeah. I think we wrote back to the committee on this
Yeah.
point. It shall be paid via the state pension credit system.
Right, and would child benefits still be the controlling benefit as long as child benefits payable to children?
I couldn't answer that point of detail, but I
that's
would
the norm at the moment.
assume, I would certainly make that assumption that is the case, but it shall be paid through the state pension credit system.
That's right, thanks.
Okay.
Clause 29. Clause 29 outlines the conditions of entitlement. The claimant has to be married or in a civil partnership when their partner dies, ordinarily resident in Northern Ireland or another territory specified in regulations, and under pension age at the time of death of the spouse or the civil partner. Clause 30. This is bereavement support payment, contribution conditions and amendments. People will be entitled to receive a full payment as long as their late spouse or civil partner actually paid Class 1 or Class 2 national insurance contributions at 25 times the lower earnings limit for any one tax year prior to their death. The clause makes provision for a contribution condition to be treated as met if the deceased was an employed earner and died as a result of personal injury or prescribed disease. Clause 31, bereavement support payment, prisoners. This clause gives the Department the power to make regulations to disqualify prisoners from receiving bereavement support payment. The clause mirrors the current legislation and disqualifies prisoners from receiving bereavement benefits and ensures the bereavement support payment is treated in line with the rest of the benefits system. Bereavement support payment is not payable to a prisoner, i.e. that would be in custody or unlawfully at large. For persons on remand, it may be repaid if not guilty or if certain severity of sentence is not imposed. And that brings us to an end to the state pension changes. The next section is for private pensions.
Okay, are we?
Happy enough.
We're all happy about the state pension side. Okay. Okay.
Yeah, no, go ahead. Thank you.
We've been joined by Doreen, who shall take us through the private pensions part.
Okay, thank you.
Clause 32. This clause and Schedule 17 requires the Department to make regulations to establish a system of automatic transfers of pension pots less than £10,000. This amount is to be revalued every 5 years. Clause 32 tackles the problem of small dormant pension pots which arise when people change jobs and join their new employer's pension schemes without transferring their pension pot. It will help people to keep track of their pension savings and plan more effectively for their retirement. Clause 33 provides a power to allow regulations to be made to prohibit incentives being offered to members of salary-related schemes to transfer their rights to another scheme or arrangement. A code of practice to encourage pension schemes to avoid offering non-pension inducements exists. Schemes breaching the code face reputational damage. Regulations to prohibit cash incentives will only be made if the voluntary code of practice proves ineffective. Then Clause 34 provides for the automatic repeal of Clause 33 if no regulations have been made under this clause after 7 years. So it's a sunset clause. It is anticipated that self-regulation by the industry and adherence to the Code of Practice will result in the demise of non-pension incentives, that would be cash incentives, as a tool to induce members to transfer their rights to another scheme or arrangement against financial advice and their own best interest. Clause 34 ensures that the power in Clause 33 will only be used should the voluntary code of practice prove ineffective. Clause 35 ensures that there will be an entitlement to a short service benefit immediately after a member has completed 30 days qualifying membership of the scheme. As you're probably aware, short service refunds are no longer available. Currently, a person with less than 2 years membership can get a refund on leaving the scheme. This only applies to those who become active members after the date of change or who rejoin after that date, having already taken a refund.
Could I just, take you back to Clause 33 and 34? The Department may make regulations to stop people being given incentives to move out of their current pension arrangements. But the intention from what you're saying is that there'll be no regulations introduced immediately. If they're not introduced after 7 years, according to 34, then that power will be removed. What will trigger the introduction of regulations?
Well, I think Doreen mentioned there when she was saying what has been issued is a code of practice and for the industry to say that that they shouldn't be offering people a lump sum of cash as a way to get them to move out of the scheme. And so what I've been having is people say, okay, well, I'm getting X thousand, I'll certainly take that, whereas they aren't looking at their long-term interest. So instead, what has been put in place is that we certainly don't have any issue with a person being offered extra pension by way of an incentive, or to go to a scheme we would offer more. We don't have any issue with that. It's just to stop these upfront cash payments, or indeed something other than cash, like a new car being given or something like that. So actually what is happening at the moment is this is actually being kept under review. It's being done by the pensions regulator. It's keeping an eye to make sure that this isn't going on, to make sure that the code of practice is actually working. If it turns out that the code of practice isn't working and that this practice is still happening, well then, at that point, but we would make the regulations. After 7 years, the assumption is that we should know by then as whether or not the schemes are actually following the code of practice.
And that was really the question I was trying to get at. What will the criteria be for deeming that it's not working? I mean, for example, there are 10 of us in the room here, employers. I offer incentives, the rest of them don't. is the code of practice still deemed to be working? And if there's no regulations, what's to stop me continuing to do that to ensure that I get out of all my pension responsibilities or difficult pension responsibilities to my employees, whilst the rest of the employers are abiding by the code?
This is something which we'll be looking at in conjunction with our colleagues in Britain and DWP. We will be looking at the whole scenario across the UK. If you're asking me whether or not, actually it's a one scheme, which is a rogue scheme, would be enough information regulation, I think what would first happen is that you would look at the actual case and the amount of money involved and what it meant. As I was saying to you earlier, for all of this field, and we have a balancing act which we try to walk between putting on extra burdens on the schemes and ensuring that the actual rights and the pensions of the scheme members are being safeguarded.
But, I suppose what I worry about with the way this is left here is that you'll always get a rogue employer or a rogue scheme or whatever. As it's left, there is no protection for people who happen to be employed by someone or in a pension scheme where these incentives are aggressively sold to them. There is no, as it will exist for the next 7 years anyway, and after that, no safeguard if no regulations are introduced. There's no sanctions on the rogue scheme or the rogue employer who tries to get out of difficult long-term pension obligations by doing this?
Well, I can't answer you as of today, but I did see now, it's a while back, and certainly at that stage the evidence seemed to be that all schemes actually were complying, actually with the code of practice. But against that, if you ever have a provision like a sunset clause, your risk is, well then okay, and so what happens after 7 years? Do they just go back to being rogue? But again, that would apply to every piece of law and every possible scenario, and we don't think it's a good idea to pass a law just to cover anything which may happen. So if the evidence is, actual schemes are fully complying, well then, our option would be, actually okay, and that we actually won't use our power to make the regulations. That said, if at any point that we did think there was a problem which the actual code hasn't sorted out, well then yes, that we shall make the regs. But I would say that we would be aiming to do this. It's in line with what is going on in Britain, because most schemes which operate inside Northern Ireland outside of the public sector are actually based in Britain. They aren't based here at all. So for the law to work, what we have to do is to keep the two laws in line. Otherwise, we could end up in a scenario where somebody here could find a hole in the law which they could exploit, or indeed vice versa. And so that's why that we have to move forward actually on this for it to be effective.
The voluntary code of practice was published in 2012, and it was produced by government and the pensions industry. So a lot of thought has gone into it.
Yeah, but there really hasn't been much time to test it. It's only been in place.
Well, it's about 2 years now, and so far, I say I couldn't give you as of today, but certainly recently, I think they were, that it did look hopeful that this was going to.
Thank you.
Okay.
Moving on to clause 36. In certain circumstances, an employer may postpone auto-enrolment for up to 3 months, and in the case of a current defined benefit or hybrid scheme, defer until the end of the transitional period, which is September 2017. Clause 36 removes the duty to re-enrol an eligible individual during a period when auto-enrolment has been validly postponed or deferred. Clause 37 contains a power to give the employer the choice of whether or not to exclude prescribed types of workers, including workers in prescribed circumstances, from the scope of automatic enrolment, but not on the basis of the type or size of employer. This is to avoid situations that are counter to the policy intention. It also allows the duty to enrol to be a power to enrol if the employer wishes, for example, where the employee is working out his notice. It also includes power to reinstate the automatic enrolment duty if the circumstances that triggered the exclusion come to an end. For example, if the worker withdraws this notice and the employer has chosen not to enrol them. Clause 38 introduces alternative quality requirements for defined benefit schemes in order to make it easier for such schemes to demonstrate that they are good enough to be used for automatic enrolment. The main qualifying criteria for a defined benefit scheme is that it is either contracted out or meets the test scheme standard. That is, it provides benefits broadly at least as good as under the test scheme. Some schemes with mixed characteristics, that is, money purchase with some guarantees, can find it difficult to meet test scheme standard, so there is a quality requirement. The requirements are a scheme of prescribed description and total contributions of at least 8%, that is 3% from employers, in line with the minimum level of total contributions into a qualifying money purchase scheme. The cost of providing benefits for relevant members require contributions of at least a percentage prescribed in the regulations, and the cost of providing benefits for at least 90% of relevant members require contributions of at least a percentage prescribed in the regulations. Clause 39 clarifies the law which sets out transitional arrangements for implementing automatic enrolment into workplace pension arrangements for hybrid schemes, namely the option of deferring enrolment until the end of the transitional period only applies where defined benefit is offered. Where only money purchase is offered, deferment will not be an option, but phasing of contributions is still available.
And is that phasing just until 2017 as well? Or?
Yeah.
Yeah.
Again, that was meant to help the employer to actually use, instead of supplementing all of the contribution from day one. It provides it to be phased. The employer used it. Okay.
Clause 40 reinstates the original policy intention that penalty notice for non-compliance with information requirements can only be used in relation to employer duties under Part 1 of the Number 2 2008 Act. Also, it ensures the regulator can seek information in relation to all of its functions and not just in relation to the general non-compliance which is under the 2005 order. Clause 41 amends the Pension Schemes Northern Ireland Act 1993 to extend the protection currently available under Section 119 regarding unpaid pension contributions where an employer becomes insolvent to workers such as agency workers as well as to employees. This protection allows schemes to make claims for payment from the National Insurance Fund of pension contributions that remain unpaid in the 12 months leading up to the employer's insolvency. Currently, where an employer becomes insolvent, the Department of Employment and Learning can pay unpaid employer contributions and employee contributions deducted by the employer. This clause extends this protection to workers such as agency workers currently not covered, and the money comes from the National Insurance Fund. Without extending the protection, two people doing similar or identical work for an employer who are both automatically enrolled into a qualifying workplace pension scheme could receive different treatment under the existing legislation depending on whether they were classified as an employee or as a worker or agency worker. Clause 42 gives effect to Schedule 18, which sets out the detail to allow the Department to make regulations to set quality standards and restrict charges in work-based pension schemes. This is to ensure protection for members of schemes that may be used as automatic transfer schemes, qualifying schemes or schemes that are closed to due accruals. And the pensions regulator will have the power to enforce. Clause 43 places duties on the Department to make regulations that require the disclosure of certain information about the transaction costs incurred by money purchase pension schemes. In addition, duties would be imposed in a similar way to require information on transaction costs and administrative charges to be published. This will allow comparisons between schemes.
But there's no limits being put on transaction costs other than
Well, there are
comparisons across one.
but under clause 42, there's a power to limit okay charges, and these two go hand in hand.
Yeah,
okay,
together.
clause 42 and clause 40. It's under the 43 is to make sure that it's made public. It means any member of the public can look at scheme A, B, and C and see which one actually charges least. Okay.
Clause 44. In 2009, the European Commission ruled that the BT pension scheme's partial exemption from payment of the levies to the Pension Protection Fund arising from the Crown guarantee constituted unlawful state aid. Following this, in 2010, regulations were made to ensure future compliance and payment of these two levies.
And this clause, what it does is to allow that these regulations to be deemed to have always been there. Okay, that effect. If we didn't do this, we would be actually in breach of the law from Europe. Okay, so it's just putting this right for European law, okay, purposes.
Clause 45 and the accompanying Schedule 19 of consequential amendments builds on the existing prohibition regime. The clause inserts a new article into the 1995 order to prohibit a company from being a trustee if one or more of its directors have been prohibited from being a trustee by the regulator. If the director who has been prohibited, for example, subsequently leaves the board of the company, the prohibition will be immediately lifted. In addition, the company is allowed to apply to the regulator for the prohibition to be waived. The regulator has the power to suspend a trustee pending consideration being given to the institution of proceedings against them for an offence involving dishonesty or deception. Clause 45, 3 to 5 allows the pensions regulator to suspend a corporate trustee where it or one of its directors could be suspended under Article 4.1AA of the 1995 order. Clause 46 sets out an additional objective for the pensions regulator, which states that when carrying out its functions in relation to scheme funding, the pensions regulator should minimise any adverse impact on the sustainable growth of sponsoring employers. This puts on a statutory basis what has already been implicit. This objective is in addition to the regulator's other objectives set out in Article 4.1 of the 2005 order. Clause 47. All occupational pension schemes are required to complete a scheme return at least once every 3 years. This is sent to the pensions regulator and provides up-to-date information about the scheme. This clause increases the maximum period between scheme returns to 5 years for schemes that have no more than 4 members. The number of members is determined either by the information sent to register the scheme or the last scheme return. Clause 48 introduces Schedule 20 to provide for a revised compensation cap dependent on the person's age and length of pensionable service when the person first becomes entitled to compensation. The Pension Protection Fund pays compensation to members of non-money purchase occupational pension schemes where the employer becomes insolvent, leaving the scheme underfunded. Anyone under the scheme's normal pensionable age when the employer becomes insolvent is paid compensation based on 90% of their expected scheme pension, subject to a maximum cap, the compensation cap, currently capped at £36,401.19. The bill introduces a new cap based on age and length of service when the person first becomes entitled to compensation. Standard amounts similar to compensation cap for 20 or fewer years. For 21 years or over, additional 3% for each year of service over 20 years, capped twice standard service. Clause 49 relates to the application of the Pension Protection Fund compensation cap to individuals who have entitlement to both an occupational pension and to a pension credit arising from a divorce or civil partnership. Where a person becomes entitled to compensation respective of two or more benefits or a lump sum under their scheme or a connected scheme on the same day, these benefits are added together before considering whether the compensation cap applies. However, where this entitlement is derived from two different scheme entitlements, an individual's own pensionable service and a pension credit arising from a divorce or dissolution settlement, the policy intent is that these entitlements are kept separate and the cap applied separately to each. Whilst current Pension Protection Fund practice is in line with this policy intent, the existing legislation requires the two amounts to be added together before the cap is applied, which could lead to a significantly lower payment. Clause 49 aligns the existing legislation with the policy intent and the current practice. The provisions of Clause 49 have retrospective effect to ensure that past payments of compensation, which were calculated in line with the policy intent but not in accordance with the legislation, are covered. And that's the end of the private pensions section.
Okay, are we all happy with private pensions?
Move on, yeah.
Yeah?
Thank you.
Yeah. We'll move on to part 7 now with simply the final provisions. Clause 50 provides power to make, by order, provisions which are consequential, incidental or supplementary in relation to any provision in the bill. Clause 52. This provision includes a power to allow amendments to be made to any primary or secondary legislation. Clause 51 makes a general provision in respect of the regulations and orders that will be made under powers under the bill. It allows the inclusion of incidental, supplementary, consequential, transitionary or saving provisions. There are standard provisions of this type common to Social Security and pensions legislation. For example, they can be used to make technical amendments and transitional provisions. Clause 52 is an interpretation clause and purely technical. Clause 53, 53(1) and 2 provide for commencement of certain provisions in the bill to come into operation by commencement order made by the Department. Clause 53(3) sets out that Part 1 of the bill should come into operation on the 6th of April 2016, but provides that any or all clauses under this part can be brought into operation earlier than this by way of a commencement order made under Clause 53(1). Clause 53(4) provides a power to allow an order to be made to amend Clause 53(3) to specify a new date for Part 1 of the bill to come into operation and to make corresponding amendments to Part 1 of the bill and any other enactments amended by it. Clause 53(5) provides that the Department may, by order, make transitionary and saving provisions in connection with the coming into operation of any provisions of the Act. And as usual, these parts are not subject to any procedure. And Clause 54 provides for the short title of the bill.
Can I ask, in 51, I think, although I think you may have mentioned 52, but 51, what might the parameters be for any possible secondary legislation?
Sorry, which part of is it you're looking at in Clause 51 there?
I think what Seamus was referring to, he actually mentioned it under 52, but I think he meant 51.
Yeah.
He mentioned the power to make secondary legislation. I'm just wondering what might the parameters be for any secondary legislation.
I'm just reading down this very quickly. Sorry, so you like 50 open brackets 2? I think he's...
Okay. 50 subsection.
Sorry, I think he meant basically Clause 50 open brackets 1.
Oh, sorry, okay.
Oh, okay. And so the Department or the Department of Finance and Personnel may by order make consequential, incidental or supplementary provision in connection with any provision of this Act.
Yeah.
Okay. It's just, each time that you alter any of the various primary bits of legislation, there will also be other sets of regs which we will also have to update, purely in consequence of what has been agreed here. So it's really to do technical amendments. It allows us to do that.
Okay.
Okay.
Thanks for that. Okay.
Okay, that's it. I see the schedules were covered as part of the clauses because the schedules link back into the clauses.
Clearly. Okay, members content with that? Seem to be. Okay, members happy enough for that briefing this morning? That's it, isn't it? Okay. Yeah, so next week obviously we have NIPSA. Again, just to remind people, NIPSA will be coming in next week. So on the basis of the presentation from NIPSA, or indeed any other information that we might have from other stakeholders, given the fact that they're advertising throughout the day, then you'll be happy enough if we invite you back again.
Oh, yes.
And explore,
Absolutely.
there's a lot obviously for members to take in, and on the back of that consideration, we'll get you back and we'll can tease further information out.
Okay.
Okay, so thanks very much.
right, thank you.
Doreen and Libet, thank you very much. Any members, any other business you need to raise for today?
Chairman, is the NIPSA presentation the same time next week then, or are we doing this on a Tuesday, or is it?
Yeah, Tuesday. That's for Tuesday morning, so yeah. I think the committee agreed last week. We'll do Tuesdays. And just before you come in this morning there, we just rehearsed that. We're going to set for the next number of Tuesdays to try to complete this as quickly as we can do within the 30 days. Although we have applied to the Assembly, as you know, for an extension just because we're hitting recess. But hopefully we'll be able to complete the business within the 30-day schedule. And then depending on what stakeholders request, we have to brief the committee, and submissions then we'll, as I say, continue to engage the department where need to be. Okay, members, thanks very much. The meeting stands adjourned.
30.